22 years suddenly fired for being injured. Want to learn why? Join us as we discuss this important case. I'm Yao Dinizulu, a discrimination and personal injury trial attorney in Chicago, Illinois. My client worked for her Chicago employee for 22 years as a union machinist when her arm got caught in a drill press and severely injured her left arm. So she filed a workers' compensation claim to take care of her medical bills and to compensate her for her lost wages. It is against the law under various federal and state laws to discriminate or retaliate against a person for exercising their public right to make a workers' compensation claim. The reason why we have those is because we want to protect, as a society, our injured workers. Her job sent her to a physician for an evaluation. The company physician gave her a diagnosis of fibromyalgia, which is a muscle and nerve injury that can be chronic, that can cost a person a lifetime of pain. The company's physician took her off of work. The employer was not happy with that situation. They immediately switched her physician to another physician who, in a $15 million evaluation, decided that she could go back to work. They sent her back to work full duty, ignoring the advice of the first doctor. She was re-injured. Once again, they pressured her after being out for several weeks to come back early, placing her on a light duty job. She tried her best. She struggled, but she did her best because she was a hard worker that enjoyed working. A few days before the Christmas holidays, when work was slow at her factory, she asked her supervisor if she could have a couple of unpaid days off. The supervisor said yes. 2 days into that week-long vacation, she was fired. They fired her because they said she had abandoned her job. We filed a lawsuit on behalf of this client. In the lawsuit, we were able to take this matter to trial. We brought a vocational expert, an economist, a doctor, and a lawyer, all who testified on behalf of our injured worker who was discharged from her job from taking vacation. We argued that it was a pretext to basically get rid of her because she filed a workers' compensation claim. But the most important witness was a fellow employee who got up on that stand and swore under oath that he observed our client asking the supervisor for permission to take those days off. The jury saw that this employee had no reason to lie. As such, they vindicated her and was able to show, through their verdict of $1.8 million, that they did not allow the employer to victimize this employee. If you have any questions about discrimination or retaliation, feel free to give us a call. This is the kind of questions that we answer every day. I'm Yao Dinizulu, a discrimination attorney in Chicago, Illinois, practicing in the states and federal court. Thanks for joining me.